All right, good evening. My name is Rachel Evans. My pronouns are they, she, and I am a legal education specialist with CED Law and the Community Economic Defense Project.
And I'm Carl Brevik. I am the community law supervising attorney and a senior attorney in tenant legal services with CED Law.
And today we have a variety of topics that are all focused on if you're navigating challenges within rented housing. So we'll start by talking about living conditions and then move into retaliation and discrimination. We'll talk about the eviction process, and then our colleague Jeannie, do you want to introduce yourself real quick?
Sure. My name is Jeannie. I am the Senior Manager of Community Relations at Community Economic Defense Project, and I'll be showing you some resources that we have available for those that are facing eviction. Thank you, Rachel.
Mm-hmm. So we're starting by talking about living conditions, and there is a law around that in Colorado called the Warranty of Habitability. There's a little statute there if you need it, but we'll get into what that law entails. So essentially, landlords in Colorado are making a promise that your rental unit is in a safe and livable condition. The landlord would be violating that law if the home is uninhabitable. Under the statute, we'll look at what that includes. If it's in a condition that materially interferes with life, health, or safety, or if it is uninhabitable after what the law calls an environmental public health event, and that could be something like a wildfire or a flood, or something man-made like a chemical spill. And if the landlord has failed to quickly or fully make the repairs with proper written notice. So this is what the law includes as requirements for a livable rental. So working appliances, this specifically deals with fridges, ovens, and stoves. Waterproofing, weather protection, unbroken windows and doors, functioning plumbing, heating, lighting, and gas, and then running water, and this is important, reasonable amounts of hot water at all times, as well as connection to appropriate sewage disposal systems, appropriate garbage removal, appropriate pest control, so mice, rats, cockroaches, bed bugs, all of those, floors, stairways, and railings in good repair, and locks on all exterior doors, and some sort of security device or lock on all windows that are designed to be opened.
What about outdoor lighting?
So like we're talking outdoor lighting like security lamps or like just the lamps in front of the door or like street lights in the parking areas?
Security lights like around the stairwells and
In the common areas?
not common areas, but like, I walk up, there's like a stairwell that kind of goes up, and it's really dark because we're in the back of the apartment complex.
Yeah.
And it's pitch black. So the light, everybody else has lighting, pretty much it's on.
Yeah.
But there's no, I guess you can call it security lighting. But it's also for people that can see to walk up the stairs,
Yeah, no, that's a great question. And that's not directly covered under the warranty of habitability as an individual condition. The standard we then look to for anything that doesn't fit one of those categories that we just described is it a threat to life, health, or safety? And the argument is that's a safety risk, right? You can't see, you might trip, you don't know what's going on. And so it's not fitting under any of these exact definitions, but any threat to safety could be considered a violation. I just can't say that for sure would be. It would depend on the judge or the situation.
And the law classifies conditions as to whether they are severe or less severe. We will look at some examples and figure out what different conditions might fall into these categories. And then we'll also talk about why this matters. But let's take a look at some examples of severe conditions first. So that could be something like a gas leak, lack of heat, October through April, hazardous or non-functioning electricity, any sort of critter or pest infestation, lack of running and hot water, lack of working plumbing or sewage disposal, and then those broken locks, security devices, windows, or doors. So these could all be examples of severe conditions. Some examples of less severe conditions could include issues with appliances that are still functioning. So for example, a stove that still has at least one burner working is a different level of severity, right, than a stove with no functioning burners on it. Any sort of mess or trash in the common areas, this can also depend on what kind of mess or trash, how long it's been there, how it might evolve into becoming more severe, things like that. And then non-functioning AC, this only applies to air conditioning provided by the landlord, whether that's central air conditioning or a wall unit, a window unit, whatever it may be. There are a few exceptions in extreme heat, but generally speaking, this would fall under less severe. And then mold has its own specific requirements under this law. So within 96 hours of proper notice, we'll talk about what that proper notice is, landlords need to install containment, stop the active sources of water, and then install a filtration device to reduce exposure and the potential for damage and harm. And then in addition to those initial requirements, the law says that within a reasonable amount of time, landlords need to maintain that containment, establish appropriate protections, eliminate and limit those sources of moisture, decontaminate and dry or remove all materials that have been exposed or affected, evaluating if that mold has been successfully remediated, and then doing any repairs or improvements to control those sources of moisture to prevent or limit the recurrence of mold.
What is a reasonable time?
Great question.
Yep.
It's,
Yeah, and so the problem with reasonable is reasonable as a legal definition is just what would an average person expect in the situation. And so the most consistent definition we see of reasonable is there active work being done on it, and is that active work being delayed unnecessarily? So if it's active and not being delayed unnecessarily, then that's seen as reasonable as a general legal description. But as a rule, again, what I always just want to reinforce is reasonable is a very squishy word. I don't get to really decide what reasonable is. No one here does. It's going to be the single judge, if this ever got in front of the judge, they determine was it reasonable. But as a general guidance, this wording came into place for the trend of landlords that would start work, and then just having started it was considered enough, and it might drag on for months or weeks. And so then they said, well, you have to be working on it. Even though this is in terms of the mold, elevators are another classic example where an elevator might be broken down, the work starts on it, and parts are introduced, or it can't be acquired for weeks. And so the landlord's like, we'll fix it as soon as we can, but the parts are gone. We're reasonably trying. It just has to be, is action happening?
And then there are also some things that, of course, are not covered by the warranty of habitability, and that would be appliances that are outside the scope of that fridge, stove, oven, so things like dishwashers, microwaves, or other appliances the landlord has provided. Problems that the tenant causes, so if there are plumbing issues due to flushing inappropriate items, if there are issues because the tenant isn't taking out trash or keeping the home reasonably clean, those would not be violations under the warranty of habitability. And then cosmetic defects, so things like faded or worn carpet would not be a violation of the warranty of habitability. And you are still allowed to ask the landlord for repairs for things that aren't under this law. It just is not as urgent as things like not having heat or hot water.
Excuse me.
Yeah.
My understanding was that appliances that are listed specifically under the lease, that the landlords provided under the lease, were also covered under warranty of habitability.
So that's a great question. And to make sure everyone heard, is the appliances promised under the lease covered by warranty of habitability? And the weird place for that is there's a breach of contract if they fail to uphold that, but certain things like the microwave or something that's considered a luxury appliance wouldn't trigger the legal defenses of a warranty of habitability violation since it's oriented to these other elements. The exception to that is if the lease frames it as this is what the landlord has established as the standard for a livable condition. A livable home will have these other things that they're signing on for a more proactive situation with. But again, in my experience, those additional items in a lease can lead to a broken contract or a violated lease provision or a lease violation, but it does not, under Colorado law itself, expand the scope of the warranty of habitability. Great question.
And we have a few examples here. So we're going to see practice classifying them into severe, less severe, or not covered. So our first one here, we have a mouse infestation. What do we think? Covered, not covered, severe, less severe?
Severe.
Severe, right? That's a big one. Our second one here, I may have flushed Legos down my dad's toilet as a little kid. If my dad had been a renter, would that be severe, less severe, or not covered? Not covered,
Not
because
covered.
my dad's kid did it, right? If my neighbor, my upstairs neighbor's kid, clogged their toilet with Legos and now there's sewage dripping into my apartment, right, it could evolve. But with just these facts, not covered. A broken dishwasher, severe, less severe, or not covered? Not covered. And another example, right, if this dishwasher is now leaking water, maybe it's evolved and it now falls under the warranty of habitability, but just not working, not a violation. Trash in the common areas, what do we think?
Not covered.
Not covered. Anyone want to guess a different one?
Not that that's wrong.
Not that it's wrong.
Less severe.
The answer is maybe any of those, right? Depends on a lot of different factors. What the trash is the trash leading to a pest infestation? Or is it some sort of dangerous stuff, right? I've lived places that have had like broken glass outside for weeks that haven't been cleaned up. So the answer to that one is depends. E here, water is leaking into an outlet. What do we think? Severe, yes. A broken ice maker? No. Not covered. I feel very strongly that all drinks that are designed to be cold should have lots of ice, and I think that the ice maker is very important, but not covered. And then our next one here, broken heat. Severe, specifically October through April, but as we have seen, it can also be cold in May, right? So the law says October to April, but circumstances can also depend. And then we have mess trash, not keeping the home clean inside the tenant's unit. What about that one? Not covered, right? Now, if my neighbor isn't keeping the home clean and that's affecting me, the conversation could be different. But if I'm like, there are bugs in my house and they're eating the food that's on my counters, that might be a me problem. And then our last two here, we have a broken toilet, but in one situation it's a 1-bathroom apartment, and in the other it's a 2-bathroom apartment. Which one's more severe? The 1-bathroom, right? Because if there's a second bathroom, it might move it down to that less severe category. Good.
I have a question.
Yes.
So back to the broken heat,
Mm-hmm.
you specified the month duration or whatnot, and not that this applies to me, but I'm just curious. So what if someone has like a medical condition where they're cold all the time, even like July, but they have some kind of documented medical condition? Would that have any bearing on?
That's a great question. And so to fully contextualize what we're talking about here, this is just violations of the warranty of habitability law itself. And so for those special cases, it wouldn't be seen as a major violation of the warranty of habitability outside of those months. But it's important to note, to Rachel's point, May is where we are right now, and it's been snowy, it's going to be icy, we're dropping into the 40s. So it's a less severe still violation if the heat is broken in those off months. Still counts as a violation. But having said that, the other thing that could happen is, I don't want to rabbit trail too much, but if someone has a health condition that requires special accommodations for something like a heat being maintained through the year, there's a reasonable accommodation request that would fall under fair housing in that situation.
Okay, that's right. Okay.
Yeah, so really good question, but yeah. And so then just make sure I'm clear with everyone, when we're talking about whether it's severe or less severe, that's still a violation, right? It just triggers these, some different steps that we're gonna talk about. Yeah, A+ work, everybody.
And then we're going to move into giving notice. So we'll talk about the best practices for giving notice and why it will trigger different timelines based on the severity of the issues. So the most important thing to know about this law is that in order for your protections to kick in and the timeline to start, notice needs to be in writing. It should be however you usually communicate with the landlord, whether that's the maintenance portal, via email, text, whatever the case may be. But until there's notice in writing, those protections have not been triggered. It's also important to make sure that the landlord is allowed to enter the home. For example, on my online maintenance portal, right, I have to click a little box that gives them permission. There's also the opportunity to clarify if you have pets, give some warning, some context for that. And then documenting as much as possible. So photos, videos, screenshotting messages, especially online maintenance portals. It's good to keep your own record of those. And then records of any health issues or any medical treatment that's required because of the issue. So if there are lots of bed bug bites that need treatment, things like that, those are documents that you should keep as well. And a lot of times, landlords will tell you to just call them or come to the office in person, or if it's a Saturday night or it's Christmas Day, there's the emergency line to call. And something to do there is to call that emergency line or talk to them in person and then recap that conversation in writing in order to protect yourself under the warranty of habitability. It's so much easier when you have that written record, time-stamped, showing when that initial conversation took place. Oops.
No, that sounds like you just did this one already, so we can move to the next one.
And so we talked about severe and less severe conditions. The reason that differentiation matters is because it triggers different timelines for repairs. So severe conditions, for example, it is January and it's 10 degrees out and your heat breaks. You provide that written notice to your landlord. They have 24 hours to begin repairs, and those repairs need to be completed within 7 days. For less severe conditions, so for example, if there are issues with trash in the common area and it's bad enough to fall under the warranty of habitability, and you contact your landlord, they have 72 hours to begin those repairs and need to have them done within 14 days. And we briefly touched on this concept of the environmental public health event. Again, that could be something natural like a wildfire or a flood, or it could be something man-made like a chemical spill. But if something like that makes the home unlivable, then the landlord has 72 hours to inform the tenant how they plan to fix the issue, when they're going to begin the repairs, and then the estimate of when those repairs will be completed. There are some options if the home is unlivable under the warranty of habitability and the tenant does provide proper notice. The tenant can ask the landlord for a similar apartment or hotel room that would need to be comparable in terms of things like how many bedrooms, how many beds and baths. The tenant should be current on rent and then would continue to pay rent because they're being provided a comparable place to live. The tenant can also provide notice that they're going to be ending the lease agreement 10 to 60 days after they provide that notice, or reporting conditions to code enforcement or some other entity if needed. Then the tenant additionally can ask the court to make those repairs. The tenant has the right to take the landlord to court. So if the tenant has been paying rent all winter and hasn't had heat all winter, the tenant could go through the court system to ask for some or all of their rent money back, depending on how bad the conditions are. this law, the warranty of habitability, is also a defense in an eviction case. So if the tenant is being evicted because they haven't paid rent, but the apartment has been full of cockroaches and mold and hasn't had heat, that could still be a defense. And then the tenant can also be potentially entitled to attorney's fees, court costs, or any other expenses for asserting their rights. Tenants can also take money off of rent to make repairs themselves, but there is a specific process that needs to be followed. So before withholding any part of rent to pay for those repairs, the tenant needs to wait at least 10 days after providing proper notice in writing, and then the tenant needs to get a professional estimate from someone who is licensed, certified, and not related to them. So for example, my dad is a licensed contractor, very convenient when I flush Legos down the toilet, but he could not be my professional estimate, even though he is a professional. And then I would provide that estimate to the landlord. The landlord has 4 business days to get their own professional estimate, and then they can ask you to use their professional to make the repairs. If all of those steps are followed, then whatever you spend on those repairs can be deducted from rent. And we have a little scenario here. So Desi gets a notice from Excel that gas will be shut off to the building because the building failed a gas pressure test. So Desi takes a picture of the notice and sends a maintenance request to the landlord through the online portal. They state that the gas will be shut off. They give permission to enter. The next day, the gas gets shut off, so now Desi no longer has heat and can't use their gas stove. After 72 hours, the landlord responds that they will have workers out to the property in 4 to 6 weeks. So, question number 1, did Desi follow the law? Yes or no?
Yes.
Yes, correct. What is something Desi did correctly?
Give notice,
Provided notice how?
with the portal.
With the portal. Provided notice with the portal. Made sure it was clear the landlord had permission to enter. Desi also took a picture, which is not required, but is really good to have, right? Better to have more than you need than not enough. What about the landlord? Did the landlord follow the law, yes or no? No. The landlord failed on both accounts, right? So the response time was too long. Not having heat and a working stove is a severe condition, so they needed to respond and begin those repairs within 24 hours. And they would have needed to complete them in a week, not getting someone out there in a month.
All right.
Tradesies.
I want to tap out. Before I jump into retaliation, does anyone have any questions about what we just talked about? Awesome. We'll jump in. So retaliation is the next concern that the legislature concerned itself with because there are still a lot of obstacles for tenants exercising these rights and then maintaining their housing. And so this law determines that it is illegal for landlords to retaliate against a tenant for reporting the condition of their home to the landlord directly, to code enforcement, or other authorities. And it's also illegal for a landlord to retaliate for a tenant organizing or joining a tenant's union or similar organization. And similar organization is something I always like to highlight. You don't have to be in a union. You can be meeting with several of your friends. We'll talk more about some of those options or several of the tenants, co-tenants that live there. But both of these are an illegal act for a landlord to take. And according to this law in particular, organizing is a key definition of things that we wanted to make sure that tenants could do. Organizing is considered any action that is lawful and intentional and is for the purpose of helping each other and or creating, supporting, or operating a tenant association or union and or using any of the other rights you have. So even if you live in an apartment building and you want to talk to your other tenants about what you learned today, that's protected organizing.
So if, like, I tell my neighbors, like, hey, let's meet in this common area,
Mhm.
or chairs, tables, they cannot call the police on me or anything?
Correct, yeah. If you're participating in lawful organizing activities, you're not allowed to have the police called on you. They're not allowed to close off the common areas for use for tenant meetings or anything like that, yeah.
What if I bring out like an outside speaker, maybe like you, for example?
It's a great question.
If they call the cops on you, even though you're my guest?
So I've had that happen before, full transparency, but
I've had that happen before.
yeah, so, but that is also against the law, because again, a lot of understandings around the fact that tenants require some help, whether that's professional organizers or attorneys like me and that sort of thing. And so this law prevents landlords from interfering with tenants participating in organizing activities, including relying on experts to assist them. Great specific questions. For examples of retaliation that we commonly see, landlords raising the rent, and again, nothing stops the landlord from raising the rent within the law, which is once every 12 months. They can raise the rent, but if the rent is being raised exclusively as a punitive measure, say, the whole building is getting a $100 rent increase, but the person that was participating in tenant organized activities suddenly has a $500 rent increase, that could be considered a retaliation. Landlords are not allowed to decrease services. That happens a lot, where all of a sudden the leasing office is closed to someone who's been participating in organizing. Landlords are not allowed to end a lease without the tenant's written consent, as, again, a retaliatory act. They're not allowed to evict or threaten to evict a tenant. And that's a big one, right? A lot of tenants have heard before, like, hey, if you don't stop what you're doing, I'm just going to evict you. Whether or not that landlord follows through with it, that threat is a violation of the law. And then taking any action that intimidates, threatens, discriminates, or retaliates against a tenant, that was a big catch-all that they threw in, because there's lots of forms in which a landlord might be able to make someone so uncomfortable for participating and exercising their rights that broadened that out a little bit. What happens if a landlord does retaliate? Tenants can use retaliation as a defense in an eviction case. They can end the lease without penalty. They will give notice to the landlord that I'm being retaliated against, here's the documentation, and I'm therefore going to leave. If retaliation occurs and say it's documented and you're able to prove it in court, a tenant can receive 3 times their monthly rent or actual damages, whichever is greater. Keynote, not both, but one or the other. And then recover reasonable attorney fees and costs, which is, again, just a general, anytime you're in court, most things will allow you to do that. So we're going to talk about this scenario. Ion's apartment has a problem with recurring mold and cockroaches. He talks to his neighbors and finds out that they have the same problems. They decide to start a union, but the landlord still does not fix the problems, so they report it to code enforcement. The landlord tells Ion that he needs to pay an extra $400 a month or be evicted. He also threatens to report him to ICE if he does not pay the extra rent and stop his involvement with the union. So first question is, anyway, one at a time, there's 3 ways the landlord's retaliating. Who can pick out one of the ways retaliation has occurred?
Raising a fee.
Yeah, raising the fee, right? Just saying, hey, I'm just going to raise your fee because you're organizing. That's a great example. What else do we see?
Reporting them to ICE.
Threats, right? Reporting to ICE. And there's the threat for the eviction. That's exactly right. So you got that. All 3 of those are examples of retaliation that I have seen before. The second thing is, we just talked about it. What can Ion do if they're facing this kind of retaliation or discrimination?
Go to the previous thing.
Exactly. Just go back one page and we can read out loud. Yeah, so we'll actually go to the next page, because don't worry, we recaptured. The main things that we're talking about is, again, tenants are allowed to break the lease if there's documented retaliation happening, because one thing that we recognized, if a landlord has just decided they don't like you and they're retaliating, and a tenant's like, this is not going to be worth the fight, I might be able to win, I might be able to stay in my home, I might be able to stop them from raising rent, but I can tell they don't like me. I want to go somewhere else. That's an option. But that's not an option for everybody, right? Especially in Colorado with the housing situation where it is. Just picking up and moving, not easy for anyone, but especially right now. So then they could take the landlord to court and recover any damages and attorney's fees that they need. Again, we always advise that could escalate tensions, but it would maintain housing and hopefully prevent that, because there's nothing that says if this case is won and the landlord turns around and retaliates some more or continues to participate in retaliatory behavior, that case could be brought again, and those damages keep occurring until the behavior stops. Again, not common, because at the end of the day, most people go, I know they don't like me, I just want to get out of here. But if that's not an option, you have the secondary option. And I kept talking about discrimination because discrimination is an often bleed over. And so it sounds obvious, but not all states have all the laws that we have. But there is a federal Fair Housing Act, right? Colorado has expanded out some of those discriminations. But it is illegal for landlords to discriminate based on protected identities, including the ones you see here, kind of the classic constitutional rights, these immutable elements of our being: immigration status, race and ethnicity, age, sex and gender expression, religion, family status, country of origin, and source of legal income. And it's important to note that we have a couple of things that are special for Colorado, right? Colorado has expanded. They've not only codified the Constitution, or not, the federal level of these laws, but expanded it out for source of legal income and immigration status. Immigration status is not protected under fair housing. Race and ethnicity is, but that hasn't always protected all people in immigration statuses. And source of legal income just basically was a protection to say landlords aren't allowed to say, I don't like that you receive a subsidy from the government. I don't like that you received rental assistance a year ago. As long as they're getting the money, they're not allowed to discriminate on legal sources of income. So what can you do if you're discriminated against? Very similar before. But one of the things that we like to highlight, and again, this even applies to retaliation, it sounds a little silly sometimes, but you can notify your landlord in writing that you are that they are violating the law and ask them to stop. And that can sound a little bit useless, right? But especially when we're dealing with a lot of these multinational corporations, there's laws that are being violated that they don't even realize they're violating in the state of Colorado. I just talked about two of them, right? So sometimes they go, oh, okay, we'll back up. But then there's also some ones that just all of a sudden, once a tenant establishes, like, I know the law, I can't be bullied around on this. Landlords will stop once they know that a tenant knows the rights they're exercising. We talked about it earlier. If you're experiencing discrimination, you can also contact your neighbors. Talk to the other people in your building, right? And if they're also experiencing it, you can take action as a group. I talked about it a little bit last week, but we've got more people here, so I'm going to say it again for this story. The amount of times I read articles that say, oh, a leasing office was swamped with protesters and they changed their policies and they fired a discriminatory leasing agent. And then you read at the bottom of the article, it's like 6 people showed up on a Saturday. And I'm like, wow, it only takes 6 people to swamp a leasing office. All right, just talk to 5 more people and you've got the ability to make change. And so it doesn't take a lot once you get more people together. If both of those have failed or you're not comfortable doing those two things, you can file a complaint with an organization that can help. We'll talk about those organizations as we continue the process. Or you can file a lawsuit against your landlord because, again, discrimination, like retaliation, is a damageable offense. And a court can award damages for each violation of the law. Because, again, there's not a lot, like a tenant can't call the cops, right, because they're being discriminated against. The only, one of the only mechanisms they have is this. And so each violation, so if you're getting a daily email, if you're recording daily harassment, each of those infractions would be used, it could be used in a potential lawsuit. And you would get a refund of any money you spent because of the violation. Let's say someone was discriminated out of their apartment, they went and rented a hotel for a weekend until they could get stabilized or figure out what's going on, or contact management, the regional manager, because the local manager is harassing them. That would be part of that as well. And the court can also order a landlord to stop breaking the law through an official order. And if a tenant's in that situation, the court is not allowed to let testimony happen about the immigration status of the tenant unless the tenant wanted to bring it up. There's some narrow situations where they might want to, but the important thing is all these protections happen whether or not you are documented or an immigrant. It's about the landlord's conduct, right? I could get, as someone who's been born in America, 3rd generation, looks like a fairly stereotypical person that came from Midwestern Minnesota. If the landlord's like, I think you're from Russia, and I'm going to discriminate against you. It's still a crime, and even whether or not I'm an immigrant doesn't get to come up, right? And so now we talk about filing a complaint. Who do you go to for help if you're doing this on your own and it's not working? If you live in Denver, the Denver Anti-Discrimination Office is a go-to. But the other 2 big ones are the Colorado Civil Rights Commission and the Colorado Attorney General's Office. The 2 things I want to note about those last 2 is, 1, it's fairly easy to fill out the complaint. but it does require you to provide your contact information, right? And so for a lot of people, that's okay. Some people don't really want to be getting that regular contact, so that can provide an obstacle. I do want to note that. But I always like to talk about how there's an ebb and flow to these organizations. These organizations, I talk to the people that work with them all the time, and they say sometimes we're so busy, it takes us 3 months to fill out a complaint or to investigate. Other times people have given up because they had to wait 3 months, and so we're sitting doing nothing. And so you never know what stage you're going to be in when you're dealing with this. So always feel free to try to reach out. If you get to the point where it's just not stopping, investigations aren't helping, we do have a variety of law firms in Colorado that can help file a lawsuit based on discrimination. The ACLU of Colorado, I'm sure most people know who that is, and so that's kind of like the A-list celebrity lawyers. They take big cases, but again, the more tenants you have encountering it, the more interested they are. CED Law, that's us. We have an affirmative wing that can help intervene when the law is being broken. And then we've got several other law firms, the Colorado Poverty Law Project, Rocky Mountain Immigrant Advocacy Network, Colorado Legal Services, and then we talked about CCRC already. Disability Law Colorado, there was a question earlier about what happens if if someone has a particular need for heat, right? Failure to accommodate disability could be a fair housing question for the Disability Law Colorado. Justice for the People Legal Center is a very engaging community member that does more than just law. And then there's a law firm called Sue My Landlord. You only get 3 guesses to know what they do as a primary function.
They're not taking cases right now.
They're not taking cases. That is also true. But I do get to announce that they're hoping to expand capacity by the end of the month here. 2 new attorneys have been hired. But you are correct. They are busy as bees.
I got a question.
Yeah.
I went to this apartment complex. I didn't end up renting there.
Yeah.
But they asked me, I think they asked me for I know they asked me for my ID and social security, but I believe they also asked me for my birth certificate. Is that legal?
So the first 2 would be legal as long as it's consistently applied across all applicants. Asking for birth certificate is not traditionally legal because there's no non-discriminatory purpose for seeking out your birth certificate. Because in the state of Colorado, whether or not you were born here, landlords can't make that a decision factor of whether or not they'll rent to you. And so they would not be able to ask for that. So that would have been a violation of the tenant application.
So they wouldn't be able to ask for that?
No, they're not allowed to ask for that.
I don't know why they asked for that. There's a lot of immigrants that live there, so I don't know.
Yeah, no, and again, sometimes it's outdated stuff. Sometimes it's just, well, we're from Texas. That's our home base, and we're allowed to do it here, so we just do it in all of our branches. I can't speak to why they would do it, but I can say that in Colorado it's not legal.
Okay.
All right. Any other questions before I jump into our evictions? We want to make sure we just talk about kind of what an eviction process looks like in our last 20-ish minutes. All right. We'll be moving on. So there's 5 general steps to the eviction process. And I want to highlight 2 things. Eviction processes compared to any other type of case move incredibly fast. A lot of people that experience it feel it usually in the last moments of this. Screen down, but it's all right. I've got some memory. What we will talk about is it always starts with the demand stage. A demand is a document from the landlord informing, there we go, a tenant what they did wrong and why the eviction's happening. And it will generally come with an explanation of what you need to do to make it, to avoid the eviction. And then we're going to talk about what happens after that stage. But the demand itself has things it has to have. A demand is not an email from your landlord that says, hey, you're late on rent and I want that money. That's not a demand. That's a communication. Demands have to be official legal documents. This is an example of what can be downloaded from the Colorado court system. So we see this a lot. It's the standard form. It does not need to be that official form, though, as long as it includes these things. It has to have the address of the property in question, the date and time the tenancy is going to end. So again, most of these are 10-day demands. So in 10 days, so by 11:59 p.m. on the 31st, you need to move out. before that. Otherwise, I will pursue further steps. It also has to include the reason, and that's a big one. The majority of these will just say you owe 3 months in rent and you haven't paid, but there's other reasons that what someone can be evicted for, and that reason needs to be there so the tenant knows what's going on. That can't just say, it can't be broad or blank. And then it needs the landlord's signature, also required. Tenants need to know who it is. And again, landlord's very broad in this category. Landlord consists of the property owner themselves. If they hired a property manager, it's anyone who manages or has an interested managing stake in the property. Also, the demand must be in your language if the landlord knows or has a reason to know what your language is. And so this is a fairly new thing, but the demand is the most important stage, really, because it lets the tenant know what's going on. And it's the only document that has to be provided in the tenant's language. Everything else can just be in standard English. But since the demand describes what needs to be done to avoid the eviction, it has to be in that language. And the landlord must make 2 attempts to personally hand the demand to the tenant. After those 2 attempts have been made on 2 different days, they're allowed to post it on your door, which is the traditional way, I think. I've seen just about everyone receive it. After the demand expires, so let's say that's step 1 of the eviction, and hopefully it never goes past step 1. If there's lateness on rent, the rent gets paid. If they're like, hey, you've got a dog, and you're not supposed to have a dog, the dog gets given to a family member. It cannot progress if the issue's been repaired in that time period. If it hasn't, your landlord's allowed to file a complaint with the court. And that now explains to the court what happened. This says, court, I gave them the demand. I said they had 10 days to pay rent. They didn't pay rent, and so now we're going to the eviction stage. And again, this is an example of the official document that can be downloaded on the Colorado Court's website. But again, a lot of attorneys will just do their own outside of this official format. And I've seen landlords do their own handwritten ones. As long as it's got the necessary information, it applies. The complaint triggers what is step 2.5, which is the tenant then gets a summons that tells them when they need to come back to court to answer what's happening. Because there have been situations where maybe the tenant never got the demand or has a different version of events or hasn't done what they've been accused of. This is their chance to communicate that to the court. They have to file the answer on or before the return date on the summons. An answer is just a legal document that we'll talk about. And if a tenant does not file their answer by the deadline, the landlord automatically wins. The court says, well, I've only heard one version of this event. The tenant didn't respond, so the landlord wins. Again, and a couple of those requirements we were talking about in the demand is because of how fast judgment can enter against a tenant. And once that happens, a landlord can schedule the sheriff to remove the tenant if they didn't respond. And I saw a hand up.
Oh, yeah, what is the time limit?
Time limit?
Yeah, what is it called, the deadline?
So after they filed a complaint, it's at least 7 days after they filed the complaint. It'll vary. Basically, the court will say they'll choose the date. And so it's at least 7 days after the complaint was filed, but there's no official timeline. So the deadline is, let's say, the landlord filed the complaint on June 1st, and the court said, you have to come back on June 8th and file by then. That would be the deadline. Does that make sense?
Okay, so they'll schedule a court date 7 days from when they file their paperwork in court?
Yeah, and 7 days is as soon as they can. We usually see 7 to 10 days, 7 to 14 days. I can't exactly tell when, and that's why it's important. One of the first things you'll get on your summons, it'll say this is when you have to respond by, and that's your notification as to that deadline.
Oh, okay.
Yeah, great question. Filing an answer. An answer is the response to a landlord's complaint, so it's the defendant's equivalent to a complaint. And this is where a tenant would say the reasons why the landlord shouldn't evict you. We talked about it earlier. For example, let's say you've been dealing with terrible living conditions this whole time. That's a defense, even if you did do what your landlord accused. Other times we have situations where, again, we're talking about Legos were flushed down the toilet. I've had tenants be accused of like, oh, it's your fault for this leak. And the tenant's like, I haven't had a leak. I don't have any plumbing problems. That's where you'd explain that. In the answer, tenants should raise all the possible defenses that they have. And I want to note that's very difficult for non-lawyers, but most every courthouse has days where lawyers are giving pro bono time to help identify defenses. Or if they can't, we'll coach you and say, there's no defenses, you might need to go back to your landlord and come into a deal about this. Big note again, even if you agree with some or all of the allegations, you may still have defenses, right? The court, because it can so quickly trigger a win for the landlord, there's a lot of steps in between to make sure everyone's doing it right. And there's a lot of protections on both sides. And so again, you might be behind on rent, but there might be other protections you have because of the landlord's misconduct. The answer form includes defenses recognized by the court. So we're going to talk about some standard defenses. There is a form that can be downloaded from the court website. That's basically a checkbox form. So you can read and see many available defenses, standard available defenses, to kind of check box off. Some examples are, you didn't do what the landlord said you did. And again, that's even been non-payment. I've had tenants say, I'm being evicted for non-payment, but they took my $3,200 out, just like always, or my $2,700 out. Your home was not livable according to the warranty of habitability. The landlord did not provide a reasonable accommodation for a disability, or your landlord discriminated or retaliated against you. Basically, these things are things that the landlord has to stop doing or fix before they can follow through with an eviction. Because again, there's no proactive, accessible ways for these things to stop. So the court has decided, if we know that this, and it's proven, key note, it has to be proven that this is happening, then you might have defenses. But the answer isn't here to prove, right? You're not doing your defenses or providing all your evidence yet. You're just saying, these are the things I would talk about if I get a chance to talk to a judge. And so you want to make sure you identify as much as possible. And so then, again, we're talking about kind of as we move through our steps, if all this has happened, the demand was given and it wasn't fulfilled, the landlord has filed a complaint with the court, you've received your summons, and you filed your answer. Those are all the steps necessary to get to an actual hearing. The hearing is where the court schedules the eviction. It's the actual conversation where everyone has to prove what happened. And it's going to include an opening statement, presentation of witnesses and other evidence. Usually, in my experience, the landlord will just present a leasing agent, and that's it, or themselves if they don't have a property management company. But anyone that has any witnesses can speak at this time. Cross-examination of the other party's witnesses, and then a closing argument. If I had everyone take out anything from this part of the slide, it's that you need to bring 3 to 4 copies of all evidence you submit. The amount of times I've seen people with really good evidence and really good defenses lose because they pull out their phone and say, Judge, can you look? The judge is not allowed to do that. The judge has to be able to keep the evidence. And so if you've got pictures, print them out. If you've got videos, put them on thumb drives. And you need a copy at least for yourself, for your landlord's party, and for the judge. Yeah.
So pictures can't go on the thumb drive?
So pictures can go on the thumb drive. Yeah, and that's totally fine. And again, especially for accessibility. If you've already got the thumb drive and you're putting it with your videos, put it all together.
But then do I need another one to show up to court? Like I need my own, one to give to the defense, one to give to the judge, or just one that I submitted to the judge?
You need those 3 because if you're just digital, the property manager or landlord and or their lawyer need to be able to look at stuff live time as well on their own devices.
So my case went to district. Let me just say that we're not in
Okay.
a normal eviction case right now.
Great.
So we've already gone through discovery and I had to disclose all that to them. Are they responsible to print this stuff up after I disclose it, or do I still need to bring it to court?
So that's a great question. In general, again, I can't speak to a specific situation, but I would say generally, I still lean on having extra copies, so it's just not an issue, but knowing the costs that can incur, I would reach out to the other party and then just say, do you need me to provide copies to you? Otherwise, the court has their digital copies and I have my own.
Okay, and then would you still say that even if you provide a digital copy, maybe create a photo album just in case?
I like it, and the other thing I'm going to say is when it comes to effectiveness of presenting evidence, there's a lot of power to being, instead of like going, scroll down and find this image, and just going, look at this image. This is bad, right? We can all see this. Look at this, and put it in front of that. So I like physical evidence, but I could say that as a lawyer who gets some support in printing out my evidence. So it's a balance. Better safe than sorry is what I'd say. I'd rather have copies when possible, so that's why we highlight that one. All right, and then at the hearing, the judge will generally make a decision that day, depending on how complex the case is. I've had cases where they take some days to think about it, but generally you learn the same day. If the judge finds in favor of the landlord would ask for a writ of restitution to issue 48 hours later. If the judge finds in favor of the tenant, the case is dismissed, and any judgment, if one was placed, is vacated, and the case would stay suppressed. Colorado is one of the only states in the country where evictions only are visible on your record if you lose or get a judgment against you. If you don't lose or get a judgment against you, the eviction stays off your record. I've had situations with colleagues in Florida where I've had literally attorneys get evicted from houses they never lived in, but it's in Florida, and so that's on the record, and they have to explain every time they apply to a house, like, I didn't even live there, it was this crazy thing. Colorado does not do that. And so the writ of restitution is one of the other big things that I want to talk about. This is the end stage. We've gone through all these steps, the hearing has happened, and the landlord has been found the prevailing party. The writ of restitution allows the landlord to schedule the sheriff to remove you after a 10 or 30-day waiting period, 30 days if you receive Social Security disability, or TANF funds. Otherwise, it's 10 days. And the sheriff will sometimes come to post notices on your door, not always, and they're not legally required to. But if they do post a notice, the next time they come back, they will be removing you. Move-outs are only between sunset and sunrise, or between sunrise and sunset. That's the law. They will not be moving out during the night. And move-outs are generally not the holidays or on weekends, because the sheriff doesn't want to be doing that, but that's not the law. It's a general practice in the state. A writ of restitution will automatically expire after 49 days and can be reissued by the court if the landlord had not exercised it in that 49 days. Only the sheriff can restore possession to the landlord. And this is really important. This is for the safety of all parties involved. We as a state don't want just people moving stuff out or reaching high conflict issues. So even if a landlord has obtained a victory in court, the sheriff will perform the eviction. Landlords cannot change the locks after they won. They cannot lock a tenant out until the sheriff removes them. They can't turn off electricity or utilities. They can't break windows or do other things to constructively evict them. A constructive eviction just means the landlord's behavior becomes so bad they force you to leave. My dad went through that at one of his properties where the landlord just basically moved in and was like, well, it's my house, and so I'm just going to live here until you're out. And that's a constructive eviction, right? That's not a cool situation.
Can I have a question?
Yes, please.
What if one of those situations happens after you come from court 2 days later? What if?
And you come out, so you come out, you've lost at court, you know you're trying to pack up, you're waiting for the sheriff, but your landlord has already, while you're at work, moved your stuff out onto the lawn, locked you out. That becomes a wrongful eviction. And so the landlord has violated the law because, again, eviction can only occur under the steps of the law, and that opens a wrongful eviction lawsuit, which is a higher penalty. And so you get up to 3 months rent back and all proper damages, or all actual damages, which means what was cost. Did a TV get broken or get stolen while it was out on the lawn? Did you have to spend a bunch of money on an emergency mover that you weren't going to have to spend money on, et cetera? And so they become financially liable for having broken the law that way.
But as a tenant, what will be the next step? Like if I come home, 3 days later and you change the locks, or my electricity is off, for example, can I go back to the court, or do I have to file a court?
Yeah, that's a great question. So the case is closed, so you don't really have the option to go back to the court. If the landlord's in the middle of doing something, you can call the police. The police in general are very aware, and again, that's for those who are comfortable contacting the police, but police know that they're familiar enough with the steps to go, that's our job, we should be doing that. And so they have intervened before when someone's doing those steps. So if it's in mid-process, if it's already happened, it's very uncommon for the court to say, all right, we're going to move them back in for 2 days and then let the sheriff come in and move them out after that. We don't see a lot of success with that. We only see kind of this financial penalty. And so, but again, if it's happening and it can be intervened upon, police can be contacted to intervene. Really great question.
Is there a special officer that does the evictions? In Arizona, they have one.
So the sheriff's office has a department that participates in the evictions, and it's generally one sheriff's office member, and then they hire out kind of day laborers to do the moving itself, overseen by a sheriff.
There's one sheriff that's a specialist in eviction.
So there's just like a whole department, because again, we have record levels of evictions in Colorado, and so it's a whole department, and they'll just go out and they're familiar with those steps. Yeah. Any other questions?
Can it be about general?
So if you have, and you got, you can ask, and if it's too specific, I'll be taking questions one-on-one after our presentation.
Okay, I think this can help others.
Yeah.
But, habitability issues out in first day you notice maybe 2, 3, 4 issues.
Mm-hmm.
Does that change anything about how fast the landlord is expected to respond, for instance?
So you're just moving in.
Yeah, like day one.
Day one. So
Haven't even filled out the move-in report yet.
yeah, so all of those timelines still apply. So if it's a severe issue, they've got that 24 hours to begin, and then has to be finished within the 7. Just moving in doesn't change those timelines, but what it does is immediately factor into the potential reduction of rent calculations. It's like, since day one, this was not livable. It does, again, open up some things, again, of terminating the lease quickly, things like that, or just revoking things, getting money back in options. But the law still does give the landlord an opportunity to fix it, even if it was immediately apparent that there was an issue. And this is born out of the fact that, again, some landlords are out of state and they just have a property manager. So it's like, once they get the written notice, they'll let that in. So it does not change the timelines despite being earlier in the process. Great. Yeah.
Regarding eviction, who is paying the bills?
So yeah, that's a great question. So if the general law in Colorado is landlords can, or the lease, I should say, usually written by the landlords, can choose one of 2 options. The lease will say, hey, if we go to court, we just cover our own costs, and I'll pay, and for my stuff, you pay for your stuff. The second option is to say whoever wins pays all the court costs. So if we get to that hearing, landlord wins, landlord can say, I'm also asking for my legal fees back, all of my filing fees, all of that stuff. If the tenant wins, they get to reversely go, I won, you brought this eviction incorrectly, or the landlord brought the eviction incorrectly, and then they get the money back. So,
And what was the sheriff once he comes? Is that of the state?
so again,
The taxpayer pays it?
so in general, like we're saying, that's part of the legal fees that the landlord can ask back. Yes, that would be part of that legal fee package. Great question. All right, well, we've got a little bit more information, and I don't want to hold this up, that I'm really excited for you all to be able to hear about. I think so. I think our time has arrived
It will be momentarily.
once we get the slideshow to load, so. Oh, yes.
Thank you, Carl.
You're so welcome. And then, like I said, I just want to make sure I'm clear. If anyone does want to stay after the session, I'm going to be fielding some questions for more particular situations, or if you've got a situation you're dealing with. Your menu options are a quick consult, or we can sit for a little time for a limited record and I talk to you about your particular issues.
And we can promote EC3.
And
That's what I was gonna say.
this Wednesday, if you are able to travel up to the East Colfax Community Collective, we're also hosting a legal consultation there this Wednesday.
Hello, again, it's me. I'm Jeannie Ruiz, and I'm here to show you or present to you a resource that is available for every Coloradarian that holds a lease. This is the Colorado Emergency Rental Assistance, also known as SERA. Oh.
It's okay. We're doing it.
Okay, thank you. So the Colorado Emergency Rental Assistance is a program created by DOH, the Division of Housing, and the purpose is to help Coloradians that are facing an eviction to get back into their feet financially, help them, with a financial burden. As we know, being behind in a couple of months can add up very quickly, so this is a way of trying to help people stay housed. This program has 3 entry points. The first one is available for those that receive a demand notice. If you receive a demand notice, you can apply. It opens 3 days per month. It's usually around the 10th. It falls around the 10th. This next round is going to be open from June 8th to June 10th. You can apply with a demand notice, like I said, or if you are on mediation. Of course, you can also apply if you have a summons, but the minimum document that is required to apply during the 3-day window will be a demand notice. The second entry point will be after those 3 days go by. We have our care center, which I will tell you a little bit more, but you can call the care center once that you receive that summons, the one that tells you that you have to go to court and show your defense that Carl just explained. And if you call the care center, they can add you to that list. The selected applicants are going to be notified by email. And the next step will be to complete a full application within 7 days. One thing that I would like to highlight is that this is a random selection. It's not by a first time, first come serving. I mean, it doesn't serve the first time, first come. It is a aleatoria selection. It's a random selection. Can I have the next one? This is another example, just like Carl shared earlier. A demand notice is going to tell you that you have to pay a certain amount, while the summons and complaint will let you know that you have to go to court, and you can identify it because it will have the court address or name on the top. Eligibility. How does eligibility look like for this program? Well, first of all, the applicants must not have received any rental assistance, state assistance, within the past 2 years. When we're talking about a state assistance, there is one called TRAG. This one used to be called ERAP. So if you got ERAP, within 2 years, unfortunately, you won't qualify. But if you get assistance, rental assistance from your county, that doesn't stop you from being eligible for this program, for the state program. This is only available for residents of Colorado and only available for the primary place of residence, which means that if I'm, someone else, I'm renting an apartment and put my name for someone else's apartment, I cannot apply for that one. I can only apply for the one that I live in. The program will only pay the amount that is owed. This is not a continuance assistance. It's only to get you out of that hardship. And once that you are selected, it will pay whatever you owe, your arrears, plus the current month. If the application is processed after the 15th of the month, then the next month will be considered the current month. The household income cannot exceed 60% of the area median income, and I will show you that in a different slide. And of course, I cannot stress more that you must be under eviction. It could be with an eviction notice, a demand, or a summons and complaint. Now, what documents are needed for a SERA application? A government-issued photo ID for every adult in the house. Notice how I'm saying government. I'm not specifying which one. You're going to need a fully executed and authenticated lease. If you are uploading your digital lease, make sure that you upload the certificate of signature that usually Adobe Acrobat or one of those programs will give you. We noticed that there has been a lot of tenants that apply, they get selected, but then their application gets delayed because they didn't upload that certification of authenticity. And you're going to need a proof of income, which can be your taxes, the pay stubs, and but if you don't have a job, we can provide you with a zero income attestation, okay? And of course, the demand documents. How to apply for SERA? There is different entry points, like I said. You can come to one of our offices. We have offices in Denver, Colorado Springs, and Durango. You can get in-person support at the Denver courthouses, Adam courthouses, in those specific days. And the Care Center, which is the main hub for folks seeking rental assistance, they can call that number, and they will be more than happy to add you to that list. And of course, with help from partners and mediators, which we have a lot of them in the state. Now, what is the difference between the monthly DOH pre-application and the Care Center opening, this daily? Well, with the monthly DOH application is only available for those holding that demand notice or higher. The application opens monthly, and the tenants can enter once per month. While the daily care random selection has a little bit more of options, it's available once the tenants receive the summons or higher. I always tell people that if you already have the summons when you apply on the DOH dates, a pre-application, you can apply also on the care center. That makes your possibilities higher, They're not going to stop you from applying on two. And then with the daily care, with the daily random selection at the care center, your application is going to be alive for 14 days in the system, so you have 14 chances of getting selected. Then on the 14th day, the care center will send you an email asking you if you want to be re-entered into the selection. If you decide yes, then your application is going to be alive again for 14 more days. The application process, what happens once you get selected? Like I said before, it's not, unfortunately, not a first come, first serve. We're looking at priority. We're giving priority to those that are more at risk of homelessness. The 2 entry points, like I mentioned before, can be the DOH monthly pre-application window. That's a riddle for me. And then the care center daily random selection. And yeah. Can I have the next one? And I think that will be it. I think I have, okay. Okay, so this shows you how does the area median income looks like. If we have a household of 3 people, I live with someone, I have a little kid, of course my kid is gonna count as a household member, but only the adult's income is going to be taken into consideration. And my household should not make more than $70,000. Because in that case, I'm not eligible, unfortunately. I'm above that 60% area median income. Next slide. And then if you have any questions, please do not hesitate. Here is the QR code for you to access our care center. The care center where you can find all the information. We also have videos on how to fill out the application. If you have any concerns, it's getting complicated. Sometimes it can be a little bit confusing filling out the application. So we have videos that were made specifically for that. If anybody has any questions, this is the time. But I'm sure someone wants to talk to Carl, many of you. And yeah, this is the evaluation for CED law, late racial takeover. Oh, and one more thing, there is flyers. If you don't have, if you want to take information for your family, neighbors, or anything, you can find flyers on the table. And I also brought flyers for another small program we have in the org, which is the utility assistance. So if you are behind on your utility bill, you can apply for the Energy Outreach Colorado, and they will pay whatever you owe to help, again, have financial hardships. Okay, now it's all yours.
And our last thing here is if you are willing to scan the QR code and do a quick evaluation, it's only a few questions. That's super helpful. I will leave this up for...
Using your help or that help with utilities, does it mean that, for example, for an immigrant, will it be public charge? Like afterwards, does it mean that?
I couldn't hear you. What's that?
Si ella recibe ayuda como inmigrante, si eso va a ser carga pública.
Later, can it be taken as if the immigrant is a public charge after they use this?
It's my understanding they know. This is a state program. This is a state program. It's not federal. So, yeah. Okay. Thank you. Thank you. Gracias, Virginia.
Thank you so much, Rachel, Carl, María Eugenia.